Some of the do's and don'ts of going to the family court that you should always remember. One of the most important ones I've got to say straight off, never mention the name of your social worker or any of the managers, social services workers on social media. Because the way that the courts look at that is, if you're saying bad and derogatory things about them, slagging them off or whatever you happen to say about them, then that could be classed, well, for one thing, it could be classed as hate speech. But the argument that social services will put to the court will be that you have put that social worker, that named social worker, in danger, including their family and friends. So that's rule number one, never ever put the name of your social worker on social media. Another thing you should remember is never to share the court documents, reports, etc. with anyone outside of the court case. Because if you do, you can be held in contempt. Contempt of a little phrase at the bottom of the documents, most documents, to say that you must not share these documents. So be aware of that. You can be held in contempt. Here's a thing that happens quite a lot. This is a very, very frequent one, and it's hard to say which is the worst thing to do, but this is certainly ranks among the top worst things to do in a family court. If the male and the female, the mother or father, are arguing over a child, verbally and in writing, and all the solicitors are putting one against the other, which solicitors will do. They'll pitch one against the other and try and cause problems between you so that you both go into the court slagging each other off, in which case the judge will throw his hands apart and say, well, I'm sorry, but social services are going to have to take this child into care because neither of you can agree. That's a big danger, and that's a big possibility if you go in arguing. It's in some people's, let's just say, some people without a soul will contrive to remove your child. So remember that when they're talking to you and they're being ever so sweet and nice to you, that really deep down and behind that cheesy smile, there are bad intentions, possibly mercenary intentions, fiscal intentions, anything, because who profits from a family court case where the family lose the children? Who's going to make a profit from that? Always, always follow the money. Remember that adage, always follow the money, and that will tell you who and why they want your children. One of the best things to do, if you can discipline yourself to do this, is to hold in your evidence, keep your evidence safe and confidential until you're actually in the court. I'll explain why. Because just before you go into the courts, both sides, or all parties involved in the case, will hand in their court bundle. Now the chances are, although they're not supposed to, we can presume that the whole thing, everything in their court bundle or your court bundle will have been discussed and mused over, and they'll be rehearsing it like an amateur dramatics play. Well, you'll come in and you'll be so shocked and horrified to hear that this person did that, and the whole thing will be like a Perry Mason show. So just bear that in mind. If they've already dealt with an issue, like say for instance somebody had a problem with drinking or an alleged problem with drinking, they can't tell the difference between an addict and somebody who has a drink now and again. But nevertheless, if that's what they're saying against you, they will have an answer ready for that. If you say, well, I haven't had a drink for so long, or I've been to an Alcoholics Anonymous club or something, really, no matter what you do, they'll have an answer for it. And no matter what defence you have, they'll have an answer for it. And whatever you accuse them of, that's another topic, but whatever you've accused them of, they will have an answer for it. So always remember that. Save it until you're actually in the court, because it will be discussed. So you go into the court with the one that the solicitor has and your little envelope, or a big envelope, with some of your evidence that hasn't been clarified or made available to the judge or the sheriff, whoever it happens to be. It's a big issue here in a lot of cases where people have had one of our parenting assessments done and an assessment done, and we can go onto the website, you'll see my qualifications, etc. And I'm more qualified than most of the social workers you're ever likely to meet. But the one thing that I will emphasise is that never ever tell them what you're going to be saying in the court. At the right moment, usually when the social worker or whoever wrote a report about you going against you, whoever wrote a report about you is under oath, then you say to the barrister, I have evidence to prove that that person under oath at the moment misled or misinformed the court. That is your golden ticket, because the first thing solicitor will say is, do you have the evidence? And you can say, yes, it's in my little brown envelope. And that's when you produce that. The judges don't want surprises, they don't want anything that hasn't been discussed. But if the issue has been discussed in the bundles, court bundles, etc., you're just adding more evidence that wasn't included in the bundle. What these solicitors are doing, they're absolutely appalling. I can assure you, they're not always on your side in this. There are some things they can't help, they just got to go ahead with it, they just got to follow the flow. But in other things, they are less than ethical, let's put it that way. Please be careful. They're not all sweetness and light, these guys. They're after the money the same as everybody else probably in that courtroom. The main thing you need to prove to the judge or the sheriff is that they have been misled and misinformed by what other people are saying or what they're omitting from the documents, in which case you've got to bring your own copies. Very quickly, very briefly, look up Starr Hobson and Arthur Labenjo Hughes and see what happened in those cases. There was an inquiry in 2022 and they came to the conclusion that the judges and sheriffs, whatever, were misled and misinformed by false reports by social service workers. So let's get that well and truly established. These people are not truthful. They are writing a report with an agenda. And usually that agenda has nothing to do with reality. So I'll save the explanations, but I think you know what I mean by now. They're contriving all these reports for a reason. They're not true because they want the children. Your children are worth money. Remember that. The only advantage you have in a family court is that you can speak from the heart, from your soul. I'm going to tell you something which you probably know this already, but when somebody asks you a question about your children, your face lights up, your eyes change, your whole demeanour changes, your voice softens, and you start smiling when you're talking because you've got these beautiful memories. So when you're actually in the court, look the judge straight in the eye. Let them see the sincerity, the love, devotion, commitment and honesty that you have when you're talking to the judge. So you tell when somebody's been honest with you, if you can look you straight in the face. But the other thing that you can do, which obviously a social worker cannot do, the other advantage that you have is you can paint an image very, very briefly, because they won't stand for this so many times or too long, but you can paint a brief image. If you can recall some kind of a situation where you're engaged with your child or children or you took them somewhere or you made them something special to eat and how much they enjoyed it and liked it, etc. That puts an image into the sheriff or the judge's head. And that's where you have the advantage. You have these memories. Social services don't. They're just writing stuff down, probably cut and paste from one person report to another, to yours. So behind all this cold legalese way of talking and procedures and protocols, etc., there's a little child, a human child. They need to be reminded of that to the judge. Distract them, get their eyes away from the documents and the papers and the procedures and such, and just tell them this is a wee boy who truly and sincerely, genuinely misses his parents, or a little girl, obviously. So let's just keep that in mind, that the judges are not seeing your children, they're seeing documents. Put an image of your child or children into that judge's mind. When social services are asking a question, you should never answer the question straight away. Never. They've been asking the same question, they've been told how to ask the same question, they've been told the wording to use, they've been told everything about what to do and what to say. So what you have to do is to disrupt that routine, completely shatter the mould that their questions have been cast in, and make them think again. For one thing, if you don't understand a question, you can ask them to repeat the question. That'd be a lot easier to understand. Another thing you can say is, well, I don't agree with the implications of that question. For instance, if I said to you, have you applied for anger management lessons? Well, why would you do that? If you have no problems controlling your temper, why would you go for an anger management? You'd no need to go for that. And if they like a domestic violence course, that would imply, this is why I don't like doing them, because it implies that there is a possibility of you being violent, when really the possibility might be zero. But still, if you've gone on a course that tars you with that brochure, that makes the judge think, oh, well, maybe he is potentially violent. So these are the kind of things where they'll try and mislead the court into thinking that you're a violent person. So never agree with the implications of a question, if there are any there. There are types of questions, or the social services or the social services solicitors and barristers will try to mislead you into giving the wrong answer. So you've got to be aware, and you have to talk this over with your friends and just go through some stuff and just try and identify what is speculation. Speculation is when they say, well, you did this at one time, so you're likely to do it again. There's a risk of you doing it again. Well, that's not true. Certainly we change every so many years, we change, and gradually different circumstances we always change. Everybody's different from when they were 5 years ago. Anything past 5 years ago, there's no record of it, so they can't prove it. So let's not go back too far, or let's not accept what is relevant today from what was relevant 5-6 years ago. Forget it. That's not relevant today. So that's when there's like speculation. The other one is conjecture, because they will put 2 and 2 together and come up with 5 just to make you look bad. They might say, well, you dress like a thug, or you hang around these pubs, or you know this person, or whatever. That doesn't make you a villain, it doesn't make you a bad person. But that's when it's conjecture. Think of the word for conjuring, magic. You're going to magical up an answer to something or a conclusion from isolated events. Like you put a bunch of flowers into a hat and you pull out a rabbit. That's the kind of thing they're saying to the court, but sometimes they get away with it. There's also some instances and some events that happened in your life that were provocation, they were provoked. I know some people call it baiting, when they bait someone to be angry, like bear baiting. So remember, your behaviour was circumstantial. No matter what happens, and if you swore or whatever you did, that was circumstantial. You don't go around swearing at everybody every day. You don't go into the shop for your groceries swearing at everybody. So a lot of things are just circumstantial, and they're done deliberately, where people have contrived to upset, especially men, because they are very quick to take offence at things, and they feel as if they have to defend themselves constantly. It's a constant state of being for a man, especially if you're growing up in a rough town. It's a constant state of being where you must be ready to defend yourself in a second. And so men are so easy to wind up. They're so easy to provoke. So if a question was provocative, or a question was challenging or confrontational, you must not answer that question, and just identify to the judge that you feel as if this is confrontational and you don't want to answer the question in its present form. They'll come up with a statement instead of asking you a question and ask if you agree with it. No, it's not a question of whether you agree with it. The thing to remember is, well, just identify that as a statement, not a question. It's a false statement, but it's not a question. They're going to be taking advantage of you. They've been saying the same questions every day of their working lives. They've been rehearsing them. They know how to word these things. You say, I don't want to answer that question because, and then think of a reason not to answer it, and that forces them to think again, and they start losing their confidence. And here's one of the best bits of advice I'm told I've ever given to people. From the Alexander technique. When you're asked a question, don't answer it straight away. Breathe in through your nose. Makes you hold your head back. And it gives you a few seconds which unnerve whoever's asking you this question. And you will see their eyes wobble because they don't know what you're going to say and they're waiting for it. So then that's when you know you've got the upper hand. Breathing in through your nose, it cools the blood that goes into your brain. It gives you that imperialist look on somebody who's asked you a question, and it unnerves them a little bit. And then you've got to think of a reason why you should not answer that question as it was given to you. You're not refusing to answer it, you're just refusing to respond to what that person said. That's one of the biggest things. When someone has written a false report about you, you wait until they're under oath and you say to them, did you write this report? If they've signed it, etc., or even if it's a manager who's just signed off on it, whatever, yeah, they'll have to agree. Yeah, they agreed with it, signed off on it, or wrote it. Did you write or agree with this particular part here that says whether it was a fib or a lie? And they will have to say, well, yes, I wrote that, yes. Then the barrister will say, what evidence do you have to prove that that was a fact? Well, the chances are that it won't be able to prove it anyway because you've got the other evidence, which the barrister will then say, well, we have evidence to prove that this particular thing was not true. And the judge will say, those lying little toe rags will try to kid me and try to have me on that this person's a proper alcoholic, a villain, or whatever it is, or a violent, aggressive type of person, whatever. And when that is not true at all, because they have no evidence to prove that. So always remember that when you go into the court. Keep your evidence quiet. This goes right back to the very beginning of this video. Keep your evidence to yourself. One image I can give you before you go is to remember the Glasgow smile. If you don't know what it is, look it up. That was a warning to everybody else in our region to keep your mouth shut. Wait until they're under oath. Wishing you all the best of luck, and my prayers go with you every time you go into court. Take care. Thanks for listening.